Welcome to Re-Regulating Access to Justice. This is a session on how regulation reform can unlock access to justice for those in need. My name is Zach DiMiola. I am a manager at ILES, the Institute for the Advancement of the American Legal System. ILES is an independent national think tank at the University of Denver dedicated to improving the American civil justice system. The American legal profession is at a crossroads. Time and again, studies show that many people are being left out of the justice system entirely, up and down the income scale. The vast majority of Americans cannot access legal assistance, let alone advice or representation if they need to go to court. Everyday Americans seek lawyers for help or consider doing so for only 16% of the civil justice problems they encounter. And this has led to an influx of people representing themselves in court, with about 76% of civil cases in state courts involving parties without lawyers. The practical reality is that people lack access to the very justice promised to them by our democracy, and this has had a devastating effect on public trust and confidence in the American legal system. So without change, the justice system is going to continue to be out of reach for most Americans. There are many factors that drive this problem, but one of the solutions may lie in the way that we regulate legal services. Many in the profession, which is currently both the regulator and the regulated, say that the current regulations are in place to protect consumers. But critics say that the objective should actually be a regulatory system that serves consumers, but also the broader public interest, keeping society and societal needs in mind, and that current regulations do stand between people and access to justice. In a few minutes, each of our panelists and I will cover different aspects of this issue. And we have with us today Jim Sandman, president of the LSC, Natalie Knowlton, who's a special projects advisor also at ILES, and Bob Glaze, executive director of the Chicago Bar Foundation. Quick reminder, we do want you to participate in the conversation broadly, so if you hear anything that's interesting, please shout it out. This coming year is going to bring changes in regulatory reform never before seen in this country. And I expect that more and more lawyers, judges, advocates, and hopefully members of the general public are going to discuss these issues. So today, our intent is to inform you, and hopefully you'll learn something new today, but we also very much want to engage you in the discussion. So to that end, there are a few themes that we're going to cover in our presentations. The first are some of the objectives, the goals that people who support regulatory reform have in mind. So for instance, a more accessible, affordable justice system is big on that list, but also a more innovative environment for legal services, a more sustainable practice for attorneys, and ultimately, hopefully, we can develop a proactive and evidence-based regulation that focuses truly on the needs of consumers. But that's not all we want to talk about today. Everybody on this panel has heard a number of concerns about what regulation reform could lead to. A few of those concerns that we want to address today is the possible risk that loosening restrictions on investment might open legal services to bad actors who don't have the interests of those in need in mind. The possibility that reform might lead to a movement towards a second-class justice system, a justice system for people with lawyers and a justice system for people who have alternative legal service providers. Question that is often asked by attorneys is, what do these proposals mean for the actual practice of law? Are we going to trivialize legal services by allowing other people to provide them? And another important question is, are we talking about deregulation? And if we are we leaving people in need vulnerable to greater harm in general? So all of these issues we hope to cover today. And the format to keep this interactive is that each of the panelists will get up and talk on a particular issue. Then we'll open it up to some discussion on something relevant at that part of the presentation. We hope to get your participation and your feedback as we move along these topics. We're going to start with Jim Sandman, who's going to set up, I think, a very important foundation for the rest of this discussion.
Good morning. I'd like to review some basic statistics about the need for civil legal services in the United States from 3 different data sources, and then tell you what conclusions I draw from the data. I'll start with a study that LSC did 3 years ago now, in 2017, that led to the publication of what we call the Justice Gap, Measuring the Unmet Civil Legal Needs of Low-Income Americans. This study had 2 components. The first was a national online and telephone survey conducted by NORC, the National Opinion Research Center at the University of Chicago, of 2,000 people who were eligible for service at an LSC-funded legal aid program. That means that they had incomes at or below 125% of the federal poverty guideline. The second component of the survey was what we call an intake census that was done at the 132 legal aid programs that LSC funds over a 6-week period in March and April of 2017. Our grantees were asked to track what happened to eligible people who came to them and sought help. Did they get service? If they got service, was it adequate service to address the problem they had or something lesser? Or were they turned away with no help of any kind? What the survey showed was that 86% of the civil legal problems reported by low-income Americans in the prior year received inadequate or no legal help. Now, this population, these numbers are based on people at or below 125% of the federal poverty guideline. The most recent numbers for the federal poverty guidelines as of 2019, new numbers should be coming out very shortly, were for an individual an income of $15,613, or for a family of 4, an income of $32,188. It is obvious that there are millions and millions of people making more than those amounts who can't possibly afford to pay for a lawyer. So these figures are a vast understatement of what the unmet need actually is. The intake census showed that 42% of the civil legal problems presented by eligible people at LSC-funded legal aid programs received no help of any kind, 0, turned away with nothing. Now keep in mind the limitations on these data. This reflects people who self-identified their problem as a legal problem and knew where to go for help. That is a small subset of the people who actually have civil legal problems. Rebecca Sandifer's research shows that one of the most common reasons people don't get help for their civil legal needs is that they don't self-identify their problem as a legal problem. An easy example being a consumer debt problem, where a person might be pursued by a debt collector operating in blatant violation of federal and state law. If you ask them if they have a problem, they'll say, yes. What kind of problem? They'll describe it as a financial problem, not a legal problem. And then even those who do self-identify their problem often don't know where to go for help. They've never heard of legal aid, or if they have, the word on the street may be, don't bother. The chances of getting meaningful assistance are so low that it's a waste of your time to try. So this is another understatement of what actual unmet need is. The next set of data that I'd like to look at is the number of unrepresented people in the courts of the United States. The vast majority of legal problems in the United States are litigated in state courts. 90% or more of all cases are in state courts. And the legal problems affecting low-income people are overwhelmingly in state courts. The National Center for State Courts reported in 2015 that in 74% of civil cases in state courts, one or both parties was without counsel, and that figure did not include family law cases, where there are huge numbers of people unrepresented. I have on the chart here, I don't know if you can read it, individual data by state which validate this, and overwhelmingly it's defendants who do not have counsel. These numbers reflect the fact that our system is simply not working for people who have to navigate the justice system on their own. When I speak to law students, I say this. I say I would hazard an educated guess that every case you read in your 3 years of law school is unrepresentative of what actually happens in the majority of cases in the United States. I am almost certain that every case a law student reads was litigated with lawyers on both sides. Otherwise, it's very unlikely that the judge would have been able to write an opinion of equality necessary to get into a case book. You need lawyers fleshing out the issues on both sides. Whenever I say that, I'm met with looks of astonishment. No law professor tells them that. They're getting a misimpression of what the justice system actually is and how it's not working in the United States today. We have a legal system that was created by lawyers, for lawyers, constructed at every turn on the assumption that you have a lawyer. It's a system that works pretty well if you have one, and not well at all if you don't. The next set of data I'd like to look at is current funding for legal aid and pro bono resources. So in the last year for which I have data for the 132 legal aid programs funded by LSC, total funding from all sources for them in 2018 was about $1,200,000. LSC provided about $410 million of that. I estimate that LSC-funded legal aid programs constitute about 65% of all legal aid in the United States. That's just a rough estimate based on, say, comparing total revenue for the LSC-funded programs and total revenue for all legal aid programs as computed by the American Bar Association. There's a little bit of apples and oranges going on here because the most recent ABA data I have are from 2017, not 2018. But there are other indicators like the Justice Index that counts the number of civil legal aid lawyers across the United States. And if you look at the total number there, and then look at the figures for the number of lawyers employed by LSC-funded legal aid programs, you come out with about 64%. So this is significant money, $1.8 billion. But look at the magnitude of the unmet need, and keep in mind that this is only resources going to organizations that are serving the lowest income people. How many billions would it take to be able to fund civil legal aid at the levels we really need to address unmet need? So sometimes people say, well, pro bono is the answer. That's the right answer. Those who are chuckling, that's the right response. So Professor Gillian Hadfield at the University of Toronto Law School has estimated that every licensed lawyer in the United States would have to do 180 hours of pro bono work a year just to provide 1 hour of assistance for unmet legal needs. The current median of actual pro bono hours is 30 per year. When do you think that's going to happen? That people are, and even then you get 1 hour. That's pro bono is not the answer. It's a part of the solution. I don't mean to diminish the value and importance of pro bono work, but we need to be realistic about how effective it can be in narrowing the justice gap. So I take several lessons from these data. The first is the system is failing. Failing. We just need to acknowledge that. You cannot look at the numbers of unrepresented litigants, at the number of people turned away when they realize they have a legal problem and nowhere to go to help, and come to any other conclusion. Second, there will never be enough money to fund legal aid lawyers to close the justice gap, nor will there be enough pro bono hours to close the justice gap. As a result of that, my third takeaway is system reform is essential. And when I speak of system reform, I'm talking about two things. First is simplification of legal process to acknowledge the fact that in large numbers of high-volume, high-stakes cases, people do not have a lawyer. If you were to design a legal system anew, knowing what we know today, that in 74% or more of civil cases in state courts, one or both parties is unrepresented, you would never design the system that we have. You would start all over again, knowing that the user you're designing for is a person who doesn't have a law degree or membership in the bar, may not have a college degree or a high school diploma, and the system would look completely different. It is doable. It is possible to do that. But as I said on Wednesday, if you leave lawyers in charge of designing that new system, you're going to get nowhere. The second type of process reform we need is a radical overhaul of restrictions on the unauthorized practice of law to permit well-educated, trained, competent paraprofessionals to do what only lawyers are permitted to do today. In proposing these solutions, I know that there are concerns about consumer protection, about the independence of lawyers. I've heard all that. If you got a problem with the proposals that are coming forward to liberalize the restrictions on the unauthorized practice of law, my question is, if you don't like them, what's your answer? What are you going to do? What is your solution to the problem? It's not enough just to say no. Propose an alternative, unless you're going to stand up and say the status quo is just fine with me. The second attitude we need to be mindful of is the tendency to let the perfect be the enemy of the good. To me, the question is always compared to what? And what we're looking at is a disaster in the civil legal aid system today. If someone comes up with a proposal that's going to make it better, I say yes. It may not be perfect. It may have problems. But don't just say no. We need to be open to the possibility that we make gradual improvement, mindful of the risks. I'm not saying ignore them completely. But we need to be aware at every step of the magnitude of the problem and the need to do something, and something dramatic now, about it. Thank you.
Thank you, Jim. So I do want to pose a couple questions now to the audience. Having heard Jim's presentation, is anyone okay with the status quo? Yeah, okay, well, it is kind of indefensible the way things look now. But Jim offers some proposals on how to approach this problem, and it is a problem I think that all of us are doing our best to find solutions to. Is regulation reform an important part of that set of solutions? And I think everyone at this panel thinks that it is in some way. But there are concerns, and I'm curious if anyone here has a particular concern about some of the proposals that they've heard, not only from Jim's perspective, but if you're aware of the proposals going on in places like Arizona or California or Utah that involve some exceptions, for instance, to unauthorized practice of law, some potential certification for professionals other than lawyers to provide legal services, or even allowing attorneys to share fees with people who are not lawyers. What concerns do you and the audience have, and how might we address those? Does anyone want to share a thought? No concerns? Oh, here we go.
Hi, my name's Carrie. I'm from Atlanta Legal Aid. So one of my concerns when I think about expanding some areas of practice to people who aren't lawyers is the need to be really thoughtful about it and set up protections for consumers around that. So like we have a bar association that a lot of us have to be members of our state bar, and the state bar takes that role in that a consumer can complain to them and say, my attorney, did all these things and violated all these rules. And we can take that certification away. So when we're talking about it, we don't see that coming in Georgia anytime soon, but when I'm talking about paralegals, about making those changes, that's something that I want to implement.
Right, and so, well, right, and so when we talk about the idea of re-regulation, if we're going to certify alternative legal or other types of legal providers, we would want to build into that certification some sort of an oversight mechanism, right? Something we can do. It's a great question. What state are you from?
Florida.
Ah, here we are. Well, this is actually kind of a perennial problem, right? Particularly, there are some very specific lightning rods that have traditionally drawn the ire of the bar, and a lot of them involve some form of regulation reform. Rule 5.4 is the first one that comes to mind because that's been, in some ways, the straw man in places like California, where the consumer attorneys of California have mobilized politically. And a task force that was set up through the courts to propose ideas was met with actually lobbying by that group. So that group just went around the courts and just went straight to the legislature. I think it's a big challenge. I'm curious if anyone in the panel has ideas on this. I would say that this is part of what's going on in the coming year and what's happened last year. Groups of people are actually starting to see movement in some jurisdictions, which is encouraging. And at Isles, we're trying to encourage a network of people to share ideas and strategies and resources so that these advocates could have a voice. Anyone from the panel?
I agree with you. When this issue comes up, it's not on. When regulatory reform comes up, the lobbying is always only on one side, against it, by lawyers. There is no effective organized lobbying on the other side. To me, this is an issue about consumers and ultimately about consumer protection. I think we've got the situation exactly backwards. I think consumers are being harmed by the inaccessibility of meaningful help that results from current restrictions on the unauthorized practice of law. I've been curious why some state attorney general in a jurisdiction where they don't elect the attorney general with support of contributions from lawyers doesn't take this on as an issue. Failing that, I would look to consumer organizing groups to take on the charge and to present the other side so that there's a counterbalance to what lawyers are saying. When I hear lawyers style this as a consumer protection issue, oh, we're just concerned about those clients who might be exposed to some unscrupulous paralegal. Well, to me, what we're doing is we're consigning people who don't have the financial means to afford a lawyer to no help of any kind. That's not consumer protection. This is a compared to what situation. Some competent help is better than no help at all. And I think you can deal with some of the concerns that have been expressed by regulating the people who, I'm fine with that, regulating the people who may not have a law degree or membership in the bar and who are going to be providing legal services. That's doable. I would recommend that the regulators, though, not be lawyers. How about having some real consumers be the ones who are the regulators?
Oh, go ahead, please.
Okay. I would just build on that and add that public outrage is what is probably going to move the needle on this front. And you see in corporate innovation, and you see in in-house and big law innovation, that's what moved the needle there, is the consumers who are repeat players and sophisticated demanded change, and they started getting it at the top tier of legal services. What we're not seeing is that consumers, because they're not repeat players, we know, though, that public trust and confidence is low. We know that they are opting out of the system, and once they realize this is a systemic issue that they share with their friends and neighbors, that I think is going to make some change.
I'd like to know what the strategies might be to get bar associations and bar foundations to see this as a kind of win-win or somewhere that helps their membership constituents. Because, my statement here is always, we're going to lose membership and, we're not on the lawyer's side and there's going to be a loss of faith. And then,
Right.
So, how do you convince associations that this is going to work for?
Right. And the question is, how do you engage bar associations and at least get them maybe to buy in or understand that some of these changes can benefit them? I don't want to spoil anything. I think Bob might have something to say about that, though.
Yeah, I will be talking more about that. The danger of lumping all lawyers into like strident opponents of this is something I'm going to touch on, but I think we should all be careful about doing that. I will ask everybody, what do you think the number one position of the legal community is on this issue? By far, it's like by a lot. Haven't thought about it. I mean, most people, you know, other than like conflicts of interest and all the rules that, you know, that govern the day-to-day practice, have not thought about the rules as they apply to the business of law since they took the bar. So I think there are strategies. I will touch on more of those, but just to get that point out now.
Yeah, and that's a good point. We'll take just one more, and then we're going to move through the process.
I just have a question. I'm from Utah, where this is already rolling out, and I was wondering what LSC is going to plan on doing to support the grantee organizations in getting some of these licensed paralegal practitioners on board and getting them, you know, actually doing work.
Yeah, so the question is, Utah's already rolling out a lot of these reforms. The question is, what is LSC doing to support some of the alternatives that are now going to be available in Utah for different types of legal service providers?
Well, LSC funding can be used to hire paralegals under a new regulatory system. There are limitations on our ability to lobby for systemic change. We observe those restrictions scrupulously, but to the extent that grantees need help in implementing regulatory reforms that state bars approve, we can help with that. I'm not aware of any barriers that currently exist in the LSC structure to doing that.
Right, and hold your questions. We're gonna continue to roll through this, and we'll have more time for questions, and what we hope also to have a conversation at the end too. So, hold on.
Could I just provide a little input?
Sure.
In 1995, I wrote the first article on the distinction between legal information and legal advice for court staff. And it is now pretty much accepted throughout the United States and other countries as the way in which the authorizing court staff, court law librarians to provide information with information with a broad definition. That is not the standard for the unauthorized practice of law. There is no legal information, legal advice distinction in UPL. That's something that the courts created to provide assistance to people coming to court. And it's worked very, very well. In California, there are self-help centers staffed with a lawyer supervisor and court staff or paralegals in every court, every county of California. Anybody coming to court with virtually any kind of legal problem can get help from those court staff. There is a huge subculture of doc prep paralegals that hang up their shingle we will prepare your documents. That's blatantly inconsistent with UPL, but it happens all the time. A lot of it comes from the tradition of the notario from south of the border, and Hispanics are used to going to those notarios for that kind of help. So just be aware when we're talking about this that the disconnect between the reality that we're living in and the way in which the organized bar conceives and talks about that reality.
Yeah, thank you, John. It's a good point. UPL sort of happens all around us, at least according to the way that the laws and rules are enforced. Natalie?
Good morning, everyone. I'm going to talk to you just for a couple minutes here, and then we'll turn it back to the audience and have a conversation. As Zach said, again, my name is Natalie Knowlton, and I am the Director of Special Projects at ISLES, where I lead our family justice reform work. I work in the area of court simplification, self-represented litigant issues, and of course, working with Zach on our Unlocking Legal Regulation project. I've been asked to set the stage for talking about legal service delivery innovation, and I toyed around with the idea of putting up this slide and just sitting down again, but I wouldn't be doing justice to my fellow panelists, so I'll say a bit more about this. Although I'm not sure after what we heard already that much more needs to be said on this front. Business as usual is no longer an option. Doing nothing is no longer an option. Our justice system enjoys the benefit of constitutional legitimacy, but it depends on public relevance. And without public relevance, without public trust and confidence in the system, we are failing. And when annual public trust and confidence reports come out every year, and we are barely pushing the majority who have some sort of faith in the contours of the court system and the legal system, and we celebrate as an industry several basis points rise, that is not okay, and that's not acceptable. I took this slide from Richard Susskind. I should say that at the outset and give credit where it's due. But I think this illustrates a great avenue of what the traditional structure looked like. The public does not want lawyers, and the public does not want courts. Rather, they are vehicles through which the public can understand their rights and have their rights enforced. And this worked for some time. And because actually we're talking, and we have talked a lot about at this conference, this partnership and where for-profit actors come in, I do want to point out that this is a for-profit and public partnership, the courts being a public entity, and many, of course, in the legal system, attorneys are for-profit actors. And so this social contract between public and private partnerships is, of course, no longer working, and we know that. It is no longer a viable vehicle for people through which to understand their rights and enforce their rights in many circumstances, whether because they cannot afford an attorney or because they go to court and cannot afford an attorney that will allow a substantively just outcome for them at court. And I would suggest this, of course, we know for a number of reasons. Cost is a big issue, but more broadly, we have a problem of scale at hand. 1938 was a momentous year for those of us who are fans of the Federal Rules of Civil Procedure. Think back, and of course, I did not crunch the numbers on this, and that's probably a benefit to you all, but think about 1938 in this country. Think about the population, the density, income inequalities or equality, as the case may have been, about geographic distance and technological issues back then compared to now. And think about how we just simply don't have a scalable justice system on our hands as it was envisioned in 1938. So we have some change. I want to talk about innovation on a number of fronts here: people, processes, business models, and technology, and that will cue our conversation together. But first, people. We've already heard from John, from others. Those of you who were in the panel on regulation yesterday heard about people who are non-JD holders offering some sort of legal help in communities. We heard from the Alaska Executive Director, Nicole Nelson, who talked about culturally appropriate, competent people, actors in the community who can play this role. So we're already seeing some of this. People in the community providing information, providing limited assistance. But the hitch here is that often information is simply not enough. Rebecca Sandifer's research, looking at B2C tech tools, I'll talk about technology in a moment, found that one of the biggest barriers between the existing tools is that this lack of diagnostic information. That is, what does this information tell me I need to do in my circumstance with this case? Lois Lupika has done some groundbreaking work in this area, looking at the disconnect between many self-help materials, existing sources of information, and people's ability to deploy that information so that they can meaningfully get their way through the system. So what is needed is advice, limited advice from people who are regulated, who are trained, paraprofessionals, as Jim referred to them, similar people like that who can, and this is not, of course, suggesting these people will substitute in an attorney's role in all contexts. These are very limited situations where most of us do realize and appreciate it is possible for a non-JD holder to give this limited source of advice. We talk a lot about process change. At ISLES, we work on court simplification all the time. This is an important part of this conversation. Court rules and processes are designed to be fairly inflexible, and so changing them is a lengthy process, but we're doing that. We're doing that in courts around the country, particularly in divorce, but in other areas, small claims, bringing up the amount of small claims court to make it easier for people to get through the process. From a legal services delivery standpoint, those of you in this room and others are automating as much as they can, reducing inefficiencies, Six Sigma-ing their process so that ultimately they're working at the highest level for their clients. Automating workflow is important in this context. We can't have a conversation about legal services delivery innovation without talking about business models. We've seen some of this change. Now, all the states authorize in one way or another unbundled legal services. I say this is a slow-moving fire because it hasn't seemed to have taken off. We're working on that, and a lot of attorneys are using that model, even if they're not calling it that. But we need more. Zach will talk about, and Bob will talk about, some of the changes to the regulatory structure that are on the table with respect to alternative business services that would allow changes to the referral structure, that would allow partnerships between interdisciplinary professionals to address the consumer problem, which is often not a concrete, simple legal problem, but rather a human problem that has multiple facets. We use this context, this example in the divorce context, where ISLES has built a model that relies on an interdisciplinary partnership between divorce attorneys, mediators, mental health professionals, and financial advisors. And imagine an office in which all of these professionals can work together to provide holistic services to a client. Also, funding is an issue for developing technology and developing innovation, allowing funding, whether it's through venture capital, other forms of investment, to come into these structures and to come into this conversation is a potential important route. Technology. This is where a lot of the conversation gets very heated. So I'll take it to the extreme right now, and I'll give an example of a predictive analytics software that already exists today. Fortune 500, in-house counsel, they're using this. Big Law, they have the capability. They have the understanding of what the likelihood of success is, given A, given B, given C, given D. They can run those metrics, and they understand how to develop strategy around that data. Consumers don't have access to that. Of course, those are sophisticated players. There are attorneys on all ends of that spectrum understanding the data and understanding how to build strategy. But it is conceivable, with some modifications, appropriate regulation, that kind of technology can enter the B2C realm and provide some sort of advice to litigants as to the likelihood and the strategy they might use to succeed in their case. But let me give an easier example, something that I don't think we think about because we tend to go to the extreme when we, battling through a head cold here. Something that we don't think about, and I'll give this example of talking to a court clerk recently. And this clerk said to me, the litigant came up and gave me their papers and asked when they needed to file. And I looked at the papers and I knew it was Tuesday, but I couldn't tell them that. So instead I had to tell them 5 days from this date. Now, if that litigant does the math wrong, or they misunderstand that I meant 5 business days, they're going to do it wrong. So we could be talking about something as simple here as a calendaring app that puts deadlines on a litigant's calendar for the flow of the case. So it's not necessarily that extreme when we're talking about technology innovation here. So I'll return, for some of you, you knew an ice cream sandwich was coming, and I'll return to the reality that we do have a 2-tiered justice system today. But this is what it looks like to me, an ice cream sandwich, because you have innovation occurring at both extremes right now. At the top level, Fortune 500, Big Law, in-house, you have an unbelievable legal service delivery innovation occurring. And with the Legal Services Corporation, Legal Aid, those of you in this room, we have innovation occurring as well. At the top level, it's occurring through funding. It's occurring through money. At the bottom level, it's occurring through necessity. But in the middle, we have a large swath where innovation might be occurring, but it's not occurring at the levels we're seeing it on both ends. And this is where we need to have the conversation about re-regulation.
Thank you, Natalie. A couple questions for the audience. are these the innovations that do work to close the access to justice gap? If we make an environment that allows for more innovation on all levels, are we going to see closure in that gap? And I think it's a question that a lot of us probably have some thoughts on, and being that we're at the Innovations and Technology Conference. But I think more specifically, are there innovations that you can think of that would absolutely help, but also are just not allowed given the current regulatory structure? It's impossible for you to actually pursue them and not run afoul of regulations. Anybody have any ideas on that? No? What do you think about the two-tier justice system? Are you convinced by the ice cream sandwich? Yeah? Any other thoughts? Go ahead. Dave.
So I think both in response to that question and also some of the earlier conversation about, what will it take for change to happen? The voices that aren't being heard that much from are the people who are directly affected. And so there are people like many of us in this room who watch the travesty that occurs on the ground and are appalled by it and urgently push forward reform. And I think the bar is starting to participate also. I mean, there are many wonderful people who are working. But the question on my mind is who will stand up and be, I don't know if it's a poster child or a leader of the movement, but on the ground, how can we find the people who are watching firsthand, not through the lens of lawyers' eyes, but through the lens of social service providers or organizers or community-based organizations. And I don't need to go on so long about it, but I guess I think for people in this room, many of us do have contact with these organizations on a daily basis through the work of legal aid organizations in communities. And so I think that's an avenue to explore. With the leaders of the social service providers and other community-based organizations in your respective communities to see what's their perspective. And also it's an imagination challenge because we all live in this current regime that does not allow people to give advice or offer representation if they're not lawyers. It's hard for people to turn that corner and start to think, well, what if 30 of our social workers were actually trained to provide legal assistance? What would that world be like? Is that something we want to fight to get? Because I think it will take some fight.
Mm-hmm. I think that's a very good point. And it relates also back to getting I think it's important to get this conversation out of this bubble of lawyers and judges and courts and actually engaging the public. And I think the challenge for all of us is to figure out the most effective way to do that, get new voices in the conversation.
A couple of thoughts I had, since we are at an innovation and technology conference. What you had to say, Natalie, about the court clerk who knew the date, and I think I would say that that's stupid, that they can't just tell them this is the date that's happening. But that's on a one-to-one, and human resources are just limited. The only scalable way to fix this problem is by leveraging technology, in my experience. Or to fix that problem, even if we change the rule and allow that court clerk to say, hey, this is going to be on Tuesday, and you have to file it on Tuesday, they can only do that with so many people. And in order to make it easier for vast amounts of people, it has to be in technology.
That's a good point. John?
So I agree, this is all amazing and wonderful. I think one thing I want to bring out is something to think about, and Natalie mentioned people, process, tools, different parts of the equation. And thank you. Solo and small firm lawyers are really struggling, right? They're in this trap where they want to help. They know that they're caregivers, but they're not trained as caregivers. They're trained as technicians. They wind up in these very technical cycles. We've done some recent study. We have a climate study that we did in the Oregon State Bar about how sort of satisfied lawyers are in their jobs. And most of them say that they're looking, or I think a majority say that they're trying to change jobs in the next 3 years, right, which is a high degree of dissatisfaction. And I think that there's a real opportunity in reaching out to those people that, yes, we need to bring in more voices, and all of this is true, and also we need to recruit those people who are providing the modicum of help in that middle of the ice cream sandwich right now, and try to recruit them to the cause of scalability, of sustainability, of creating better lives for their clients and also for themselves, right? They're running themselves ragged, they're leaving the profession. There's just a really big degree. Joshua can give us all the data from the Clio Trends Report. It's kind of bleak. So I just wanted to bring that perspective, that there's this population that is going to take cultural change within the legal profession at large, and there's a population that is struggling that I think can be recruited to the cause.
Yeah, that's a great point. I mean, lawyers are a stakeholder in this conversation, and we live at a time where an unprecedented amount of people can't get legal assistance, but then lawyers who are providing legal services are having a really tough time making ends meet. It's almost the definition of a market failure.
Hi, Caroline Nevin from Courthouse Libraries in British Columbia. I think the problem is that the rule makers earn money from the way it is right now. So until you can remove, so I'll use BC as an example, and Jamie's here, he'll back me up on this. When something radical happens, even at the bencher table, where the benchers in the best interests of justice want to make changes, they aren't just lobbied from the ground up, they are threatened in terms of a turnover in the next election. So until you can remove that in some way, who the regulator is, and I take Jim's point about not necessarily being lawyers, although I would argue you have to have lawyers involved, but you have to remove them from the population that makes money from the current system.
Yeah, it's a great point. The notion of an independent regulator is something that ISLES is working on. It's also something that motivated Utah to set up its regulatory sandbox, which I'll be talking about in a little bit. I'm going to hand it off to Bob Glaves, and he'll cover some new topics here too.
So I'm the guy who's defending lawyers today and the bar. For real, as I mentioned, most people in the profession have not really thought about this. And most of the people who are in bar leadership typically and in courts, we'll talk about in a second, but in bar leadership tend to be from more well-functioning areas of the practice. So their day-to-day realities are not what we're all talking about and seeing here necessarily. And so, part of this is an education situation, because most people have not formulated a position on this at all, and in the profession I'm talking about. Before you even get past the profession, I agree with everything that everybody has said about getting beyond that too. So keep that in mind, and then when you do, we do have a task force that I'll talk a little bit more about in a second, that the bar is leading, and the idea of this is there is a position in the bar world that if we take this on, we're going to lose members if we just talk about it. It's a ridiculous position, but it is some people's position. But when you start from where we're all at, and everybody nodded and agreed when we all agree the status quo is untenable, if you start from that, from a real leadership standpoint, it's malpractice as a bar leader to not take this on, because it isn't working for lawyers, it's not working for the public, and it's not working for the courts. So when you put those three together, that's the profession before you even get beyond us. But there are parts of the profession that are working, so what can we learn from those areas? So the trial lawyers, I think, come up because that's a pretty well-functioning area of the market. If you've got a contingent fee case and you've got a good case, chances are you're going to get a lawyer who's going to be able to help you and it's going to work out. If you're in the corporate space, same thing. There's a very competitive market serving the Fortune 500, and as Natalie pointed out, lots of innovation going on. Legal aid, doing amazing work. So many of you in this room on the front lines doing it every day. It's a funding challenge, but the work itself is excellent. So it's that ice cream sandwich in the middle. How do we get to them and talk to them in a way that doesn't treat everybody automatically as a protectionist and Neanderthal, which is, honestly how it sounds a lot of times when I hear these conversations, is the bar is just getting in the way of everything. Well, the bar hasn't thought about it enough to get in the way of everything yet. Before we assume that, let's try to educate them about, first of all, why the status quo is untenable, and then secondly, what can we actually do about it? And so that's what we're really trying to do with our task force. The other thing that Natalie touched on a little bit too that comes up a lot with bars who are maybe not there yet is they want to see proof that this is going to work. It's, you know, as humans, we're all kind of hardwired to be resistant to change. Lawyers are even more hardwired to be resistant to change because, you know, we're steeped in precedent. We're using words from 400 years ago regularly, you know, so we've got all the human tendencies and then we've squared them up a little bit more, right? And so this idea that there's got to be proof. Well, there are some, I'm looking at Chaz back there, there's some innovators all over this room here who know better. You know, the proof is in the problem. The solution, you got to try stuff and start seeing how it works and then adapt to how it works to make it work, you know. And so if we're looking for proof that something's going to work, I and others have used the Uber taxi analogy quite a bit. And some, you know, there are definite differences between law and taxis, I understand. But that's what happens when you sit around and wait for something to be proven, is what happened in the taxi industry. And that's the leadership we have to start providing as bar leaders, those of us, and all of you can be a leader in your own bars, to say we can't just sit here and wait for something to happen. It's do or be done unto. Okay? That is the world around us right now. Stuff's happening whether we like it or not. And these artificial intelligence things that are coming around and that we've heard a little bit about over the course of this conference, that genie's not going back in the bottle. People are voting with their feet with these technology solutions, these self-help solutions as they come online. And that's all going to go around us as a profession if we don't get out in front of it. So I'm just going to touch on what our kind of philosophies are here, starting with the status quo is untenable, that we want to improve access to justice for anybody with a legal need, which, again, this goes well into the middle class. This is not just low-income people, where you have a spectrum from self-help all the way up to extended representation. And all of us know in this room, you really need lawyers for a lot of situations and are better off having a lawyer in a good chunk of them. You don't need them for everything, though, right? We need to do a better job of like making the rules allow for this spectrum, but then also educating the public about how to use these, the diagnostic point. But we want to make the practice more sustainable for lawyers too, and you set up the point perfectly, which is saying your solo small firm lawyers who are not trying to serve the high end of the market or are not in PI are more and more struggling. And it is a market failure, is what it is, because we know people aren't getting the legal help who need it. And an example I'll give that IELTS and actually up in British Columbia, I believe too, they've had studies of pro se litigants. You know, you've seen those stats already today of would you be interested in getting limited scope representation if you could get a lawyer who could help you with just certain parts of this case? Overwhelmingly large percentages of them are very interested in that idea. Very few people are pro se because they want to be. So lots of interest in limited scope. Then you survey lawyers. Would you be interested in giving limited scope if it could get you new clients that you're not getting right now? Also, high percentages say they would love to do that. They're not connecting right now. That's a business problem. That's a business problem fundamentally. Is these people want the help, and there's lawyers who say they'd give the help, and they're not connecting to each other. So this is important. If we want to help lawyers be more sustainable, we have to look at how do you make the business more sustainable. And then the last point is a big one too, because I am in that club of having not really looked much at the ethics rules since taking the bar 30 years ago. And when you read them, we started working on this by looking at the marketing rules, which some of you are familiar with, marketing and advertising rules. And Rule 7 in particular. Has anybody looked at Rule 7 anytime recently? It's just a few people. Well, if you look at it, and I practiced for about 10 years. I've been doing more systemic work for the last 20. I could not make any sense of our Rule 7. like what you're allowed to do and not do. And I talked to the head of our regulatory body, and it turns out he's representative of others, said, yeah, we don't really know what it means either. And we don't really try to enforce it unless somebody's doing something shady. Okay, so, which is good, right? You know, that's what we want regulation for, is to get the shady characters out. But there's all these things that are not happening because these rules are so complicated and confusing unless people really push the limit on that. So we want to regulate it with as light as hand as we can to get the fundamental principles covered, which is protecting the public from harm and enabling market forces to better fix this problem. And so then here are our just broad objectives here, is empowering the public to determine and obtain the level of services appropriate to their needs, protecting the public from harm, not just general harm, but harm from purchasing or receiving bad legal advice or inappropriate services. So that goes to the educating the public about this. Enabling lawyers to compete on a level playing field. Now, this is a critical part of our message here, and we fundamentally believe it, that regulatory reform and the health of the practice are not opposing forces. They are tied together. We need the profession to be sustainable to get to access to justice, and if we're going to get it done, we have to make it easier for lawyers to compete. So we want lawyers to be able to offer the full range of legal services, and some of you may have heard me say this the other day, but my friend Will Hornsby points out our rules were made for one-on-one client relationships, and you made this point a few minutes ago as well. It's that you would be looking at a client, getting their consent to doing limited scope or doing this or that or conflicts. When you're online, it doesn't work like that. We need to regulate in a different way to recognize online services if lawyers are going to be able to provide those. And then the other point, which I was making earlier, is we want to allow lawyers to tap into the marketing, business, and technology expertise to succeed. If you're a solo or a small firm lawyer, you're basically expected to be the CTO, the CIO, the CMO that you would see in any big law firm, all in one, and be a good lawyer. What percentage would you gather of our profession can do that? Like a tiny fraction, right? And so if we want people to be able to succeed, they got to be able to get into networks or partner better with businesses like LegalZoom and others, in a more real way that connects more directly to the consumer. To be able to have different business models to compete in the modern world is a big piece of this. And then we do want to protect the independence of lawyer judgment. That's a big part of our principles. And then finally, going back to the complexity point, use plain English. Plain English for how we talk to pro se litigants. It doesn't have to be on that level. Plain English that your run-of-the-mill lawyer could maybe understand what we're saying we're trying to do here. Again, we talked about this on a different panel the other day, and it came up yesterday, but we talk all the time about the unauthorized practice of law, but what is the practice of law? How do we define the practice of law? Nobody's really been able to come up with a definition that doesn't sound like I know it when I see it, but we're all against it. So we are dead set we're going to define the practice of law, or die trying during this task force, in a way that your average lawyer and your average member of the public can actually understand what we're talking about. And it looks a lot like what John was talking about, the same advice we give clerks and others who are in self-help centers about what's legal advice and what isn't, as opposed to like these really complicated definitions that have come out. So that's what we're trying to do. Remember, there are enlightened bar leaders out there. Don't give up on them right away. Try to bring them along, okay? Thank you.
I think, Bob, one of the points that Bob makes is that some of these rules of professional conduct are really, they're economic regulations, right? You think about Rule 5.4 that prevents an attorney from sharing fees with someone who's not an attorney. That's a business model regulation, and the purported goal, objective of it is to protect the independent judgment of the attorney, and I think that protection, that independent judgment of the attorney is very sacred to the profession, and it underlies a lot of these economic regulations. But is it really that direct of a connection? Or is there a disconnect between what these economic regulations are and the notion that they might affect the independent judgments of the attorney?
So I just got handed this, so sorry. But I'm going to take advantage of it. I love everything everyone's doing, so this is not an objection at all. But back to the ice cream sandwich, that's also very representative of the not just the justice gap, but the wealth gap and the income inequality gap. And I really have to say that I think that what we really are looking at also, unfortunately, is a failure of an economic system called the capitalist system, I mean, whatever you want to call it, that it really is working very, very poorly. And so that wealth gap affects, as we've said, not just our clients, but it's creating more clients, and it's creating great difficulties for the private bar to get behind anything like this, because I think that all relationships are unfortunately economic and transactional at their core. And when we say they can't afford their health care and they can't afford their housing and they can't afford to fix their car, I'm not talking about the clients, I'm talking about the lawyers. And I at least know many, many lawyers who would love to go into small practice and do modest means and do sliding scale. But I'm sorry, we're not Canada. And until people have health care, until people have some kind of economic security, then the formula is, well, I'm doing sliding scale, but my husband's a doctor. I'm in legal aid, but my wife is a corporate lawyer. And is that the model? That's not the model, obviously. We really need to broaden it out so that everyone can take part in a sea change. Because I do agree, I don't think the bar is Neanderthal at all. I think people are just economically pressed, and the downward pressure on all of the classes is just making it impossible to do this. And I think that we need to look at this as a part of economic reform in a much larger sense, and not just the bar. And I just love what you're doing. And we who have been into unbundling for many, many years, really don't disagree with any of this. So I just thank you so much. But I hope that people understand that there's really good reasons why lawyers are having a problem with this, or wanting to have a bunch of paralegals that they can work with. Who's going to pay these people? People have to make a living. So I feel very strongly about it on that level. And then hopefully there'd be less clients if things improved.
I think you were probably the right person to have the microphone.
Well, someone else?
David, behind you there.
I thought that was super well said. The downward pressure on everyone is paralyzing in some respects. But it takes me back to the earlier point. I'm not sure where it came from about what would be in the financial interest of the private bar, and are there ways to develop those ideas? I'm not sure I have the answer to that question. I mean, I think the question is also pertinent in the context of what is in the interest of the legal aid bar. It's sort of a variation on the same question. Because in the legal aid bar, there are resistances to, executive directors have pressure from unions. It's important to think through, what would the new world look like? One thought, which sometimes surfaces in conversation, is that having greater range in terms of stratified roles for non-lawyers that extends beyond paralegals would give executive directors and organizations more discretion to deploy people in different settings to do different things. And when I say different, I mean more settings and more things than they do now. Certainly in many legal aid organizations, at least in the urban centers, there are lots of non-lawyers who are employed in those organizations, but there are finite limits on the kinds of things they can do. And again, people live within the current system, so it's hard to imagine what it would look like otherwise. But same in the private bar, and here I know less still, but the idea that there could be a range of attorneys and non-attorneys all in different roles, and that's a business model that might be interesting and profitable, is something I think under-theorized or in need of further development. I think it's difficult exactly because of the observation that was made about the downward pressure and the underemployment of attorneys, but it is something to develop further.
John?
I love all this. I want to express a minor but it may be important quibble with what Bob has on some of those slides, and that's the word protection. And I think we need to check ourselves a little bit as a profession, as an industry, when we self-appoint ourselves the protectors. There's a tendency towards paternalism that maybe isn't appropriate. Protection as a value is the polar opposite of accessibility as a value. And so when we emphasize protection, we necessarily de-emphasize accessibility, and what we have is an accessibility problem. So I'm not saying there's not a role for protection. I think it's very important, but I think it's a term that the industry uses a lot, and it means a lot of things to a lot of people. And I think when you value protection, there's the risk that you will get protectionism in all of its forms. And that's a big part of what we're up against right now. So use the word, but let's think twice and see if there's a better word when we talk about protection.
Thank you, John.
You know, I think when we talk, I mean, I love the one that you have on the top, empower, right? I think if we empower the public, if we serve the public, right? You know, Rule 1.2 is the allocation of responsibility of between lawyer and client, right? We don't get to appoint ourselves to speak for people that haven't hired us professionally. So we need to think about those values. I like empower. I think when we talk about protecting, I'm missing where it is, professional independence, again, I think that's important. But when we talk about, we need to talk about the quality of legal services. We need to talk about integrity. We need to talk about some things that maybe aren't just protection.
Thank you, John. We're almost out of time, and I wanted to make sure, I've got a little bit of a few slides here that actually deal with what's happening on the ground now in places where reform is taking place, and I'd like to get to that. So my name is Zach DiMiola, right, and I am a manager at ISLES. I manage our projects that involve the delivery of legal services and legal education, and one of the projects that I manage is called Unlocking Legal Regulation, which is a project that attempts to squarely deal with these issues. I want to say up front, ISLES has two very important tenets in all of its projects. The first is that if we are to fix the American civil justice system, we need to put the people who are in need first. This is the user-centered design idea, but it should apply to the solutions that we propose for the civil justice system. The second thing that is critical to ISLES projects is empirical evidence. We're looking for data-driven solutions. There is precious few evidence that the rules that we have currently in place do what they are purporting to do. No one is actually collecting much data on them. So, you know, we're not okay with unfounded assumptions. And if the data shows us something that we weren't prepared for, well, then we turn and we change our track, because it's the outcomes that we set out to accomplish that are most important. So for unlocking legal regulation, there are a few things that ISLES are doing, and I'm going to run through these pretty quickly, but essentially we are trying to serve as a resource nationally for anyone who wants to engage in these reform activities. We are supporting improvements and facilitating efforts to improve regulation by trying to educate judges, lawyers, and even the general public. To that end, there's a resource center on our website called Knowledge Center you can go to, where we posted a whole variety of resources, including what's happening now, for instance, in Utah, or some of the more important scholarly articles on what could be or what should be. Ultimately, what we're doing is we are looking to develop essentially a model regulatory framework, an independent regulator. Lawyers would be involved in that regulator, but the market participants wouldn't be regulating themselves anymore. We are looking towards risk-based and outcome-based regulation that relies on evidence, hard evidence, as opposed to the rule-based regulation that we have now. And ultimately, we hope to develop not only a model framework for regulation, but a model regulator that could scale out nationally. To do that, we're assessing and supporting pilot projects. We've partnered with Utah in their regulatory sandbox project, and we will be assessing the outcomes of that project to see what it can accomplish. There are a few things we're doing now, ultimately getting the word out, trying to build networks of people interested in this topic, and trying to get as much information out there as possible. If you're interested in getting involved, please feel free to contact me or go on our website. Current regulatory efforts, I'm going to focus on Utah and Arizona because they're the furthest advanced right now. Both states are actually implementing recommendations from their task forces currently. Bob mentions the Chicago Bar Foundation and the Chicago Bar Association have their task force. I want to mention that the Connecticut Bar Association also recently announced a task force on this. ISLES is serving in an advisory capacity to that task force. So, a tale of two states. What are Utah and Arizona doing? I think the Venn diagram nicely shows that there's actually quite a bit in common here. Both states are looking to revise rules that govern advertising, like the rules in Rule 7, referral fees, and eliminating that Rule 5.4, which is the rule that forbids lawyers from sharing fees with people who aren't lawyers. If that's going to happen, then both states have decided that they will engage in entity regulation. So traditionally, lawyers are regulated, but businesses are not, right? The law firm itself isn't subject to the bar, but the lawyers who work there are. This is a different form of regulation with the idea that lawyers and people who aren't lawyers are going to be working together and owning that entity. These are the alternative business structures that exist in places like England. So they're going to develop new rules around what that would look like. And of course, both states are looking at independent paralegal professionals. The differences are that Utah's going to create a new regulator and a regulatory sandbox where you don't have to be a lawyer. If you propose a legal service to the new regulator, you essentially make an application. The regulator goes through a risk assessment of that legal service. Are the risks of that service being provided by the applicant greater than the benefits they'll provide to the public? This is not protecting the public. This is serving the public interest. It's a more complicated analysis, and it's based on as much data as they can collect from the outset on demographics and legal services and societal issues, but also all along the way. If this legal service provider is accepted into the sandbox, one of the requirements for that sort of limited licensure would be, periodic audits. They would look at outcomes, assessments to see if the clients are getting the outcomes that they seek from that legal service provider. That's essentially what risk-based regulation is. Arizona, on the other hand, is going to continue to regulate through the bar. They'll have that entity regulation set up, but the bar will retain the ability to regulate those entities. But they're also doing a few specific discrete things, which I think are worth mentioning. So pilots for domestic violence licensed legal advocates. So these are lay advocates, people who are not lawyers, but who know the process to help people in need. They've also expanded their licensed document preparer program. So people can be certified for doing discrete services. Now these people in Arizona can appear in court. They can't exactly represent somebody, but if a judge has a question, that legal document preparer can answer the judge's question. This is just a quick summary of what entity regulation will look like in the two states. Now, this is all in flux. Both states have implementation task forces that are trying to structure this as we speak. But right now, it's looking like, as I said, Arizona will have a certification program through the bar for these alternative business structures. A lawyer must participate. There must be a lawyer involved. And in fact, they're using a model that's similar to what Australia has done, which essentially certifies or identifies a particular lawyer within that organization who represents or is responsible for the ethical compliance of that organization. In Utah, they're doing a two-track system. If there's lawyer participation, so for instance, a traditional law firm decides that they want to offer a partnership to somebody who isn't a lawyer. Maybe a construction firm wants to make an architect a partner. They just need to register with the new regulator, but the new regulator doesn't really do anything. They're still going to be regulated by the bar as individual lawyers. It's just that Utah wants to collect the data on who's pursuing new and differently available business models. On track B, that's your sandbox. You don't have to be a lawyer. You don't have to have a lawyer involved to propose a legal service. The new regulator is going to regulate under the court. It's going to be a part of the Utah Supreme Court. It's going to take that risk-based approach in phase 1, which right now is looking like it may last 2 years and may last a little longer. Phase 2, depending on what the outcomes are when we measure and see what we can accomplish, Utah is considering making that regulator a nonprofit independent entity. It would come out from under the Supreme Court and be its own entity. The Supreme Court would essentially delegate the authority to be a regulator, as they often do for state bars. And eventually the question is, if this is very successful, will that regulator regulate all legal services? And might that regulator then also regulate lawyers on a risk-based assessment? What does risk-based regulation measure? Harms and benefits, right? In Utah, here are some specific examples of what they're talking about. Harms exist such as consumer achieving an inaccurate or an inappropriate legal result. They want to know when that happens. Consumers failing to exercise their rights through ignorance or bad advice, or purchasing an unnecessary or inappropriate legal service. Those are 3 factors in that risk-based assessment. Benefits would include more legal services available to consumers, or better legal results that are being obtained by consumers, or equal to better services than are currently accessible, available at a lower cost, right? Those are some of the factors that go into the risk-based assessment. How do they get the information they need to evaluate these factors? I think I already mentioned a couple of things, but some of the things they have in mind are things like secret shoppers. Someone working for the regulator goes in, get a legal, for a legal service, and then evaluates the quality of it, assesses the interaction. There's going to be, I think, a robust consumer complaint process. You can file a complaint with the regulator, for instance. And as I said before, in order to participate in the program, you have to provide some basic information and be available for things like audits with the regulator. So that's what's going on today in regulation. ISLES is doing its best to serve either as an advisory capacity or to employ our research to evaluate the outcomes. Our hope is that when we see what happens in Arizona, when we see what happens in Utah, we will then have something even more to talk about. We'll have something to show for it. And this conversation could be advanced even further. I think we've probably gone over, but if anyone has any questions, maybe we can take a couple. If you want to leave, you can leave. That's okay. Or you can see us after the panel as well. Well, thank you.